Welcome once again, dear friends. And this is a recent video. In news, uh, parliamentary privileges. तो पहली बात ये न्यूज में क्यों था? Recently, parts of the leader of the opposition speech on the motion of thanks on the president's address were expunged. ठीक है, तो ये आज न्यूज में था. तो मोर ऑन न्यूज देखा जाए क्या है इसके बारे में. The experts point out that this is against the parliamentary privilege of the MP enjoyed under Article 105 of the Constitution. तो parliamentary privilege की बात किस आर्टिकल में की गई है? आर्टिकल 105 में. अब ये सोर्सेज ऑफ प्रिविलेजेस इन इंडिया किस तरह के प्रिविलेजेस हैं? तो कॉन्स्टिट्यूशनल प्रोविजंस हैं आर्टिकल 105 एंड आर्टिकल 194. ये कॉन्स्टिट्यूशनल प्रिविलेजेस हैं, प्रोविजंस हैं. Article 105 and Article 194 deal with the powers, privileges and immunities enjoyed by the members of the Indian Parliament and state legislative assemblies respectively. ठीक है, ये इनको कॉन्स्टिट्यूशनल प्रोविजंस दिए गए हैं किस आर्टिकल में? आर्टिकल 105 एंड आर्टिकल 194. इसके बाद स्टैच्यूटरी प्रोविजंस क्या है? द कोड ऑफ सिविल प्रोसीजर 1908 provides for freedom from arrest and detention of members under civil process during the continuance of the meeting of the house of the committee. तो जब हाउस ऑफ द कमिटी की जो मीटिंग होती रहे, ओके, तब उनको जो है स्टैट्यूटरी प्रोविजंस का ये रूल लागू होता है. और द कोड ऑफ सिविल प्रोसीजर्स 1908 प्रोवाइड्स फॉर फ्रीडम फ्रॉम अरेस्ट. उनका अरेस्ट और डिटेंशन नहीं हो सकता है अंडर सिविल प्रोसेस ड्यूरिंग द कंटिन्यूएंस ऑफ द मीटिंग ऑफ द हाउस ऑफ द कमिटी. तीसरा पॉइंट है privileges based on the rules of procedure and precedents. तो इसमें है चेयरमैन हैज अ राइट टू रिसीव immediate information of the arrest, detention, conviction, imprisonment and release of a member. The privilege based on rules of procedure and precedents. इसके अंतर्गत चेयरमैन हैज राइट, जो चेयरमैन हैं उनको अधिकार है कि इमीडिएट इन्फॉर्मेशन, तुरंत उनके पास ये खबर वो ले सकते हैं, पहुंच जाए कि अरेस्ट, अगर कोई इस तरह का MP MLA है तो अरेस्ट, डिटेंशन, कन्विक्शन, इम्प्रिजनमेंट एंड रिलीज ऑफ अ मेंबर. ये सर अबाउट पार्लियामेंट्री privileges. Parliamentary privileges are legal immunity enjoyed by member of legislature in which legislatures are granted protection against civil or criminal liability for certain actions done or statements made in the course of their legislative duties. इसीलिए बहुत सारे माफियाज वगैरह जो है ना, बाहुबली माफिया, जो कभी वंस अपॉन अ टाइम एंटी सोशल एलिमेंट्स होते हैं, ये कहीं न कहीं इस प्रिविलेज का फ़ायदा उठाकर, ताकि उनकी लाइफ सुरक्षित हो, वो माननीय बन जाते हैं. उनको पार्टियां टिकट दे देती हैं, MP और MLA बन जाते हैं और फिर वही हमारे ऊपर अपना एजेंडा लागू करते हैं. तो इससे भी सावधान रहने की ज़रूरत है. और आगामी जो इलेक्शन है, इस तरह के लोगों को बहुत सारी पार्टियां अपने सीट्स को क्लियर करने के लिए, सत्ता पाने के लिए इस तरह के शॉर्टकट अपनाती. Parliament is the sole authority to ascertain if there has been a breach of privileges or contempt of a house. No court is entrusted with this power. If the presiding officer gives consent, the council can either consider the question and come to a decision or refer it to the committee or privileges. A 10-member panel in the Rajya Sabha and 15-member panel in the Lok Sabha. Okay, so this is it. Now, types of privileges: individual privileges and collective privileges. Individual privileges क्या कहता है? These are the rights that each member of the parliament has in his official capacity. For instance, MPs are free to speak their minds in the House में जो बोलेंगे उस पर कोई कार्रवाई नहीं. No member will be arrested in civil cases during the session of Parliament. Third and not fourth one, not required to serve on juries etc. Not required to serve on juries etc. Now collective privilege क्या कहता है? These are collectively conferred privileges and are more generic in nature. For instance, the right to publish documents, reports and discussions. Next, to forbid others from doing the same. The courts are prohibited to inquire into the proceedings of the House. And next is right to receive immediate information of arrest and release of a member etc. तो ये हमारे टाइप्स ऑफ प्रिविलेज है जिसकी चर्चा ऊपर भी की थी. अब इनका महत्व क्या है? सिग्निफिकेंस ऑफ पार्लियामेंट्री प्रिविलेज. पहला है फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन, इंश्योर इंडिपेंडेंस ऑफ एमपीज, इंश्योर कलेक्टिव राइट्स. ये मैंने पढ़ तो लिया है लेकिन ये छूट गया, तो एक बार टाइप्स ऑफ प्रिविलेजेस के को देख ले जल्दी से. इंडिविजुअल प्रिविलेज की बात हमने की थी, तो इंडिविजुअल प्रिविलेज, these are the rights that each member of the parliament has in his official capacity. For instance, MPs are free to speak their minds in the House. No member will arrest in civil cases during the session of Parliament. Not required to serve on juries. Collective privileges में है, these are collectively conferred privileges and are more generic in nature. For instance, the right to publish documents, reports and discussion, to forbid others from doing the same. The courts are prohibited to inquire into the proceedings of the House. And last one is right to receive immediate information of arrest and release of a member etc. Or significance of parliamentary privileges. Freedom of speech and expression, ensure independence of MPs, ensure collective right of parliamentarians, and last one is reduce undue influence. Freedom of speech and expressions. Without parliamentary privileges, MPs would not be able to fully represent their constituents' interest, and MPs would not be able to scrutinize the government without fear. Ensure independence of MPs. Parliamentary privileges is an important principle that protects the ability of MPs to carry out their role without fear of legal repercussions. Ensure collective rights of parliamentarians. It gives MPs a great chance to carry out their duties effectively and independently. To give them some right to exclude strangers, to punish members and outsiders for breach of their privileges etc. Reduce undue influence. It assists in ensuring the efficacy of the activities done by legislatures and their independence, shielding them from unwarranted criticism. Now the limitations to privileges क्या है? Freedom of speech, Article 121 of the Indian Constitution, and no immunity and right could be claimed and held back by the members for anything which is said outside the proceedings and premises of the parliament से बाहर अगर कुछ करते हैं तो उनके ऊपर वो इम्यूनिटी नहीं, अनलिमिटेड इम्यूनिटी नहीं है. Freedom of speech should be according to the constitutional provisions and subject to the procedures and rules of the parliament provided under the Article 118 of the Indian Constitution. Article 121 of the Indian Constitution confers that the member of the parliament is not allowed to discuss the manner and judgment given by the judges of the Supreme Court and the High Court. Article 121 of the Indian Constitution confers that the member of the parliament is not allowed to discuss the manner and the judgment given by the judges of the Supreme Court and the High Court. अब ये challenges क्या हैं? Challenges associated with the parliamentary privileges. Against natural justice, legislatures can become the sole arbiters of their privileges, and against constitutionalism or the doctrine of limited power, and discredits separation of power. Okay, so against natural justice, The breach of privileges laws often indicates the fault for allowing the politicians to become judges in their cause. Next is this raises concerns of conflict of interest and violating basic fair trial guarantees. Legislatures can become the sole arbiters of their privileges. They decide what constitutes a breach and appropriate sanction in the event of breach. Next, against constitutionalism or the doctrine of limited power. The absence of codified privileges gives unlimited power to the House to decide when and how a breach of privileges occurs. Next, it discredits separation of power. As the presiding officer acts as a complainant, advocate, and judge used as a substitute for legal proceedings. तो ये हमारे challenges थे कि challenges associated with the parliamentary provisions against natural justice है. Legislatures can become sole arbiter of their privileges against constitutionalism or the doctrine of limited power and discredits separation of powers. ओके, तो ये हमारे थे सुप्रीम कोर्ट जजमेंट रिगार्डिंग प्रिविलेजेस. क्या है भाई? इन पीवी नरसिम्हा राव वर्सेज states stated that the members need the wider protection of immunity against all civil and criminal proceedings that bear a nexus to their speech or vote. In the MSM Sharma case stated, whenever there is a condition of imbalance between the provisions of Part 5, Article 194, 3 and fundamental rights conferred by Part 3, the fundamental rights will remain supreme over the others. Codification of parliamentary privileges. The question of codification of privileges is very old. The question of the codification of privileges is very old. It was argued in the Constituent Assembly regarding codification, but it was voted out on the ground that when a new situation arises, it will not be possible to adjust to the same. Need for codification will be consistent with the fundamental rights. Need for codification will be consistent with the fundamental rights. Will bring them under the ambit of judicial review and will remove arbitrariness in their application. The argument against the codification of privileges. More advantages would flow to persons bent on redefaming Parliament. Next, the courts will be called upon more and more to intervene. It would make the revolution of new privileges not possible. अब इसका रास्ता क्या है? वे फॉरवर्ड. इसका रास्ता क्या है? चलिए. Amending Article 19(2), amending Article 19(2), wherein the expression contempt of legislature should be added. This course of action would remove some uncertainty from the area, while at the same time the House would not lose its flexibility of approach. Next, the Committee of Privileges should be given separate independent status. It is usually observed that the members of the committees don't have a non-political approach while performing their duties. Collective decisions क्या है? The committee headed by the speaker or the chairperson, as the case may be, should be empowered to decide and investigate the contempt proceedings. Transparency. There should be a relaxation of the rules against reporting of proceedings before parliamentary committees. The general principle should be that the proceedings should be open and reportable unless the public interest clearly requires otherwise. Conclusion. Final conclusion क्या है?